Welcome to County Portal, your simple source for local government services and public records. Let's get started.
So, you filed a motion in court, and now you're waiting. And waiting. It leads to one of the most common and frustrating questions in the legal system: how long does a judge have to rule on a motion? The short, and often maddening, answer is that in most cases, there is no hard and fast deadline. Unlike the deadlines you and your lawyer have to follow, judges often operate without a strict shot clock. This isn't because they're trying to be difficult, it's a result of judicial independence, overwhelming caseloads, and the complexity of the law. Let's break down what influences the timeline. First, consider the type of motion. A simple procedural motion, like asking for an extension, might get a ruling in a matter of days. But a major, case-altering motion, like a motion for summary judgment that could end the entire lawsuit, is a different beast. For that, the judge has to review hundreds, sometimes thousands, of pages of evidence, briefs, and legal precedents. This process can easily take several months, and in some complex cases, even longer. Another huge factor is the judge's docket. Your case is just one of hundreds or even thousands on a judge's plate. They are constantly juggling criminal cases with speedy trial rights, emergency family law matters, and a long list of other civil lawsuits just like yours. A judge in a busy urban court will likely take longer to rule than a judge in a quieter, rural jurisdiction. The court system itself also matters. Federal courts and state courts have different rules and caseload pressures. Some states have internal goals or guidelines suggesting judges should rule within a certain time frame, like 60 or 90 days, but these are often not strict, enforceable deadlines. So what can you do if you feel an unreasonable amount of time has passed? Your first and most important step is to talk to your attorney. They will have a feel for what's normal for that specific judge and courthouse. After a certain point, it is perfectly acceptable for your lawyer to make a polite inquiry. This is usually done by sending a letter or calling the judge's clerk to gently ask if the court needs any further information and to check on the status of the pending motion. It's a subtle nudge. In extremely rare and drastic situations, there is a legal tool called a writ of mandamus, which is a request to a higher court to order the lower court judge to make a decision. However, this is a very aggressive, last resort option that is rarely used and can risk annoying the judge who still has to decide your case. Ultimately, patience is a necessary part of the legal process. While the waiting is difficult, it's usually just a sign of an overburdened system, not a reflection on your case itself. Trust your lawyer to know when and how to follow up. Thanks so much for watching. If you found this information helpful, please give this video a thumbs up and consider subscribing to the channel for more simple explanations of complex legal topics. We'll see you in the next video.